This is an interesting email and a common debate as to what to do about parking charge notices. Many of us get those little yellow slips and either go into a panic or laugh it off and put them in the bin. I've heard all sorts of different responses. Now, before we get into the meat of the video, two things. First of all, there is a distinct difference between a parking charge notice and a penalty charge notice. The penalty is a fine. The parking charge is not. The parking charge, whilst it might look very similar, and you can hazard a guess as to why that probably is not the same as a penalty. So different rules apply. I'm talking about parking charge notices in this video. And secondly, if you're new to me, I'm Daniel Shensmith, a barrister of England and Wales, and I'll be very grateful if you hit that subscribe button. And even if you watch my channel regularly, please do hit that subscribe button because, first of all, sometimes you get unsubscribed for no apparent reason. And secondly, many of you just don't subscribe anyway. About 60 to 70% of you don't subscribe. So please do that. It's the one metric I like to measure my channel's success, and I'm grateful to you for doing that. So thank you very much. So let's get into this email that was sent to me by one of you guys, my viewers, and says, several years ago, I was chatting to a friend. His son lives and works in London as a solicitor. We were discussing parking charges. He said his son had a drawer full of parking charges from private car park companies. Not the council or police. Those are the penalty charge notices I was talking about. My friend said his son just ignores them and does nothing. Not one response to the many letters from the company, firms of solicitors, even bailiffs, with all manner of threats of court, fees increasing, costs, etc. And eventually they stop writing. In my case, my viewer writes, I took my daughter out to lunch on Sunday near Christmas. I parked in Redacted, which was of course closed on a Sunday. You're allowed 2 hours free parking, but the car park on Sunday was empty, so I'm not causing any harm. In any event, I overstayed by some 20 minutes. There's a camera, and I received a parking charge notice some weeks later. I checked with my friend, and he again told me if I did nothing, no contact at all, not even one response, all would be well. So that's what I did. I had letters from the car park company, then solicitors, then a debt collection agency, and finally from a big firm of bailiffs. Now, there's a misnomer here because many people do get contacted by bailiffs, but bailiffs cannot actually do anything at all unless there is a county court judgment against you. So all they can do is write to you and demand payment. That's all they can do. Unless there's a judgment and there's a writ or a warrant of control, then they can't do anything else. Eventually, after all the threats, etc., the letters stopped. That was about 2 years ago. My question is, my viewer writes, how is this possible? There must be something in law, at which point I pause for a caveat. This video is not legal advice. It's just my views on this situation and my general guidance. My viewer continues, they knew my name, address, registration of my car, but that is all. Is it possible they could not take me to court as they did not really know who was driving the car? I've watched many of your videos and have noted that your advice was not to ignore these matters, but in my case, all I can say is the advice I was given actually worked to my great advantage. I will finish that sentence. So far, it's worked to your advantage so far. That being, they haven't yet taken you to court, because the general situation here, the reason I say don't ignore these things is because they can and very often do take people to court. Take the Beavis and Parking Eye case. It went all the way to the Supreme Court because it was appealed on the basis that it was unfair and various other things, and arguing that it was a penalty clause which would be unenforceable. But Supreme Court said no, it was perfectly fair. And this is the case that sets the bar for parking charge cases now. There are lots of distinct differences between different scenarios and facts and everything else that can and sometimes do distinguish cases from the Beavis and Parking Eye case, but the Parking Eye case is the one to base a benchmark on. But very broadly speaking, when somebody thinks that it's just going to go away because they haven't heard from them, they may be surprised several years later, because the limitation period in England and Wales is 6 years for simple contract. Now, I'm not going to talk about Scotland because there's a whole other debate about Scotland, so I'll leave that for another video. So I'm just distinguishing for those that like me to distinguish that I'm not talking about Scotland in this video. For England and Wales, the limitation period under simple contract is 6 years. And so even if you've heard nothing for 2 years, you can still hear from them right up to the point of limitation, and they can still file a claim in court. They should still comply with pre-action protocols informing you that they're going to file a claim, etc., which can have cost implications later on, but they have 6 years within which to do so. As to the other question, which was they didn't know who was driving the car, well, that is where a separate piece of legislation comes in. That is the Protection of Freedoms Act of 2012, which means that the parking charge is recoverable from the registered keeper of the vehicle. That is if they've sent a notice to keeper, and Schedule 4, which applies where the driver of a vehicle is required by virtue of a relevant obligation to pay parking charges in respect of the parking of the vehicle on the relevant land, and they've not been paid in full. And it's immaterial whether they were permitted to park there, etc. And under Section 4 of Schedule 4, the creditor, the car park management company, has the right to recover any unpaid parking charges from the keeper of the vehicle, provided they have complied with certain requirements. For example, a notice to keeper and 28 days has elapsed. So it is very much not the case that if they stop contacting you after 2 years, that's it and you're off the hook. If it's after 6 years, then yes, then the limitation has expired and they won't be able to claim. It'll be statute barred and they can't claim against you. And just because they don't know who was driving doesn't mean they can't claim against the registered keeper of the vehicle. Different rules apply for a hire vehicle. It's a notice to hire, which from memory is 21 days. They provide a notice to hire to tell them who was driving the vehicle, and so on. And so if they don't know who is driving the vehicle, they can issue this notice to keeper, and after 28 days, they can then claim those charges from the registered keeper of the vehicle. So if you are the registered keeper of the vehicle and you weren't driving and you know who was, you should be going to them to pay the parking charge notice. And of course, there are all sorts of other ways of potentially challenging these parking charge notices in the first place more generally. For example, if the parking operator was not actually responsible for the land, that might be one argument. If you actually followed the parking rules and they are just flat out wrong, then again, that might be another way of arguing it. If you did actually buy a ticket and display it and they just missed it, obviously that would be another valid reason. You would have to show evidence that you did actually pay for parking. Likewise, a permit. I've previously had a parking charge notice when I did have and did display a permit, and they gave me a parking charge notice anyway. To be fair to them, they were perfectly reasonable, and they cancelled it because they obviously missed it, because it had fallen off onto the seat and they should have been able to see it from the window and just didn't look very far. Then all the usual arguments, such as the signs were unclear, unreadable, too far away, ambiguous, unfair even. In other situations, you just weren't the registered keeper of the vehicle, or it's been stolen, or it's broken down, the pay machines were out of order, or a whole list of other reasons that could potentially mean that a court might find in your favour, and you should make those representations to the parking management company and follow any appeals process, failing all of which they can then take you to court. But remember, the bailiffs cannot just simply turn up and start taking things away without a court judgment and a writ or warrant of control to enforce that judgment, because it has to be enforcement of a judgment debt that they can come and enforce things like that. So I hope that is useful. My general guidance remains the same, as in don't simply ignore them. If you have a genuine reason, you should make that clear to the company, because a court will ask you the same thing. The main reason I say that is if you do ultimately end up in court challenging this, the judge will say, why is this in court? Did you not tell them this in the first place? And if you didn't tell them that in the first place, then it's less likely to be true, just because you've never mentioned it before. It's a bit like a defendant that never mentions that it was self-defense. For example, when they are cautioned, you do not have to say anything, but it may harm your defense if you fail to mention when questioned, something that you later rely on in court, and anything you do say may be given in evidence. So if they fail to mention that it was self-defense when they were arrested and interviewed, and then in court they say, well, actually it was self-defense, then there might be an adverse inference drawn against that defendant for failing to mention it when questioned in the first place. So very broadly speaking, the credibility and the chronology and the consistency of evidence is true in civil cases, which these are. So I hope that's useful. Please do make sure you subscribe. And as always, thank you for watching.